to our People Matter education-focused webinar on settlement agreements, our new slightly snappier approach to webinars. A half-hour slot this morning, but hopefully you'll find it really useful as we look at all of the issues across the HE sector that are of particular relevance when looking at settlement agreements at the moment. In terms of housekeeping, there'll be a recording of the session which will be available afterwards. That will be sent out by email and also available on our website, so that'll be there for you. If you'd like to ask a question as we go through, please pop it in the Q&A box. The chat is disabled, but put it in the Q&A. We'll try and pick out a few towards the end of the session, particularly if there's some themes that are coming through. And it'd be great if you could answer or respond to our feedback survey. It'll pop up at the end of the session. If you can feedback to us, that'll be really helpful in shaping the future sessions that we do. Great, so what are we going to cover today in the next half hour? We've got quite a lot of content, most of which I think is genuinely very relevant and topical at the moment on settlement agreement. So we'll spend a little bit of time firstly looking at some of the strategic considerations when looking to enter into a settlement agreement with an employee. When might that be appropriate? What are some of the tactical considerations? And look at a few legal points around how settlement agreements work, because they are statutory creatures. They're not necessarily quite as simple as they appear. We'll then spend a good chunk of time looking at recent developments around confidentiality provisions, freedom of speech, and non-disclosure agreements. That's obviously a huge area, isn't it, at the moment? We've had the sector pledge, the Higher Education Freedom of Speech Act, ACAS guidance has been updated. We've got the OFS condition of registration in draft form E6, all of which potentially impacts on this area in quite significant ways. It's obviously a very fluid area at the moment. And then what we'll try and do at the end is just put it together with some practical tips, thoughts for you in HR. How might you take forward some of these changes in this fluid area to ensure that you're on top of what you need to be on top of? So lots to get through. As I say, if you've got any questions, pop them in the Q&A feed as we go through, and we'll see if we can pick them up, or some of them at least, towards the end of the session. So let's crack on, shall we? Firstly, strategic considerations on settlement agreements. Sam, over to you.
Perfect, thanks Alex. Hi everyone. So when we think about whether to enter into a settlement agreement, it's often a case of taking a real step back and saying, is it appropriate for us to be talking about settlement of potential claims or settlement in connection with an agreed exit? And when is the right time to be having that discussion? So on the slide are some advantages of settlement, and I think it's helpful to talk about a circumstance in which it might be really appropriate and hopefully easy to talk to an employee about a potential agreed exit. So for example, if you have an employee who has been struggling in their role, they've had a lot of informal coaching from their manager, you know that the next stage would be a formal capability process. That's going to be quite undignified for the employee. You genuinely think that they may struggle with that process. They may really struggle to come out of that with improvement because you've been working with them for a long time on this. And you think it might be, in light of the management time that will be used, in light of the fact that this is all going to be quite difficult for the employee, and quite frankly, you think they might just be in the wrong job, you think it might be appropriate to talk to them about whether they want to potentially consider an alternative, which would be to leave employment under an agreed exit settlement agreement. Now, that's almost a kind of classic case where it might be appropriate to have that conversation. You still need to think about the right timing for that. Would you, for instance, start a capability process and then talk to the employee about their options, or would you say to them, look, this would be the next stage in the process, but would you be willing to think about something else? And that will meet pretty much all of the advantages on that slide. But then if we think about the disadvantages of settlement, it will cause us to think a little bit more about those cases where we really do need to have a think before we start approaching an employee or deciding that we might want to look at a settlement agreement. So taking the top point, you need mutual agreement. If you've got an employee who fundamentally disagrees with the view that the college or the university is taking of the situation, and they think they absolutely should be in employment, they're no interest in discussing terms of exit or settling the claim that they've already brought, then there's not much point in talking about settlement. And what it might just do is make the employee feel under attack or that actually cause more damage to the relationship there. And that's worth bearing in mind, because if settlement discussions fall through, then depending on the way in which you approached it, whether you had full without prejudice protection or whether you were having a different kind of conversation, what's called a protected conversation, that discussion might be something that the employee can refer to in a tribunal case if they're, for instance, bring a discrimination case later. And that whether or not you end up with that conversation and the fact that the employer had offered terms of exit, whether that ends up in a tribunal, the sheer fact that you've had the discussion could worsen the relationship and make everything that little bit more difficult. There will also be times where, on a point of principle, you don't want to talk about settlement. You are, for instance, investigating very serious misconduct, and you think it's important that you complete that investigation and that you don't make any financial offer to the employee to make this all go away. And that is obviously something that you as an institution will want to think about carefully, with an eye to what your regulators or your students or your other staff members may think as well of this situation. And that Alex will come on to talk about confidentiality, but I think it's often wise to assume that the terms may not remain confidential, and you want to make sure that all the decisions you've made are ones that you are happy to back if somebody does start asking questions about them. The bottom of the slide also mentions other issues that you absolutely need to be aware of, which is how much this is all going to cost, and have you set yourselves a precedent by agreeing a settlement agreement that you don't necessarily want to keep up with. So that's a bit of a whistle-stop tour of the sorts of things that you might want to think about before you launch into a discussion with an employee about settling potential claims or agreeing terms of exit. But then if you've got to that point where you've had those discussions and potentially reached terms, then we also need to think about what it is that the settlement agreement looks like. So as Alex mentioned, the settlement agreement for employment law claims is a creation of statute, and you need to meet particular requirements in order for that settlement agreement to validly waive statutory employment law claims. So the agreement is only binding and effective if it is in writing, it relates to particular complaint or particular proceedings, the employee has received independent advice on the terms of the agreement and what that means for them from an advisor who has been identified, and often that means they're going to sign either the agreement or a certificate, and who has insurance covering the advice they've given. What that means in practice is that you're going to need the employee to go off and speak to an advisor who can give them advice on their situation more generally and whether these terms are good ones. So it's important to bear that in mind as you're discussing points, because everything will need to be considered by the employee and their advisor before they sign. The agreement also needs to state that all the necessary conditions have been satisfied, and this is intended to be a settlement agreement under the statutory provisions. So that causes us to feel a little bit like, well, you know, a lot of settlement agreements are therefore going to look very similar. They're going to include a lot of the same terms. And to some extent, that's true. But from a practical perspective, there's actually quite a bit more to it than that. So moving on to the next slide, thinking about practically what a settlement agreement looks like. The first point to be aware of is that settling future claims under a settlement agreement, so claims arising after the date of signature, is quite difficult. And there's been a recent case, Basgate and Technip, that does confirm that. So sometimes what we'll find, for example, is that you enter into a settlement agreement with someone quite senior who agrees to see out one more academic year or 2 more terms, and you sign the settlement agreement, and then they work that further period and then they leave. Now, any claims that arise between the date of signature and the date of termination are unlikely to have been waived by that settlement agreement. So often we do what's called a double settlement agreement or an affirmation certificate. We ask the employee to sign another letter in an agreed form after their termination date, confirming that they don't believe any further claims have arisen during that period, and to the extent they have, waiving them. That will also require the employee to go back to their independent advisor, but that's something that's quite common. That said, whilst we've got a fix for that issue of a long period between signature and termination date, there can be implications for the taxation of any compensation that you're offering. So we would recommend sitting down, taking advice, talking to us before you agree a long period between signature and termination, so that we make sure we're treating the payments appropriately from a taxation perspective. What this all means, in addition to kind of thinking about those situations where settlements are signed before termination, is that you kind of will also struggle to settle claims that arise after termination, such as victimisation arising from the employee being bad-mouthed in the market later, for example, because of the fact that they brought a claim. That's one of the factors of signing a settlement agreement. There is, to some extent, just needs to be dealt with. There can be an alternative route for settlement agreements where you might be able to waive some future claims if you sign a COT3 agreement, which is the agreement you would usually have negotiated through ACAS, the conciliation service, if an employee has brought or threatened a claim. Those agreements tend to be shorter, and that means you might not agree so many logistical points around, for instance, future assistance of claims. There are disadvantages and advantages to both agreements, and we generally advise taking advice before you decide on one or the other. But it's something that's worth being aware of if you're thinking about time points around waiver of claims. The other thing that is really important to remember about settlement agreements is that there's often quite a lot that goes into a settlement, especially a more complicated one. And as I say, it's easy to think that a lot of the clauses are the same, so what we can do is reach for the agreement we signed 3 months ago and change the name, the date, and the extent of the compensation payment, and we're good to go. It's really worth sitting down with a pen and paper before you reach for that last agreement you signed and thinking, what is it that we need to do as part of this settlement? Because the last thing you want to do is heavily negotiate and sign a settlement agreement, breathe a sigh of relief, and then 1 month later get a letter from your employee asking where the output from their data subject access request is and when are they going to receive a response to their grievance appeal, because you forgot to say in the agreement that both of those points were now being dropped. So we'd absolutely advise that you think really carefully to make sure that absolutely everything that you need goes into that agreement when you're drafting it. But now that's the practical tips on settlement agreements and strategic considerations. So I'll hand back to Alex, who's going to talk about confidentiality and NDA.
Great, thanks, Sam. Well, this is probably the big topical issue at the moment in this area, isn't it? Confidentiality provisions and NDAs and settlement agreements. I suppose the first point to think about here is a settlement agreement an NDA? That's a question that sometimes I am asked. Is it a non-disclosure agreement? The short answer is yes, it can be, and it depends on what the settlement agreement contains in terms of its clauses, particularly around, obviously, confidentiality provisions. If you have certain confidentiality provisions in a settlement agreement, it will be an NDA for the sorts of purposes that we are talking about. There are obviously legitimate and inappropriate uses for settlement agreements. It's not wrong to use a settlement agreement. In most situations, it can be done. It's just a case of making sure terms are tailored appropriately, given the particular circumstances. We're going to look at some of those issues in a moment. There are some existing legal exceptions that you've got to be careful of in terms of ensuring that you have carve-outs for things like whistleblowing, reporting criminal offences, regulatory investigations, those sorts of things. And obviously, as we've always had, there are high-risk factors in certain cases that warrant careful scrutiny. Is the person a senior employee? Are they covered by the CUC guidance on severance payments, which they will be if they're earning more than £100,000 a year in the sector? Is there a particularly large payment being made that would have to be reported in accounts? Are there particularly sensitive circumstances here that, as Sam said, you'd want to be careful that if they come out, you're happy to stand behind? Are you trying to subvert findings of an internal disciplinary or grievance investigation? All of these factors we've had on the radar for a long period of time, but there have been some recent developments that are really bringing some of those issues into sharp focus, and I think sort of underpinning them in a slightly firmer way. I suppose the first is the NDA pledge, which came in just over a year ago in early 2022, promoted very strongly by the then university's minister, Michelle Donnellan, essentially around asking universities or trying to persuade them firmly to sign up to a pledge not to use NDAs in certain circumstances. And there's been lots of pressure to sign up. I know there's been pressure internally from many institutions, from VCs, senior leadership teams, often on HR leaders, to get this thing signed up to. I think we've got about 82 out of 132 institutions now signed up. So it certainly has been effective from that perspective. The issue here has always been around the ambiguity of the wording of the pledge. What exactly does it cover? You'll see on the slide there that it refers to sexual harassment, abuse, or misconduct. Well, that's clear. Shouldn't be entering into an agreement that seek to silence people who've raised those sorts of complaints. But it also refers, doesn't it, to other forms of harassment and bullying. And there's been some ambiguity around, well, what does that relate to? Does that relate to more serious matters, only those involving protected characteristics? What about a low-level, so-called low-level bullying case? Someone who alleges bullying during a performance management process. Is that covered by this pledge? What about the amount of the payment being made under an agreement? All of these issues have come into sharper focus with the appointment of Professor Arif Ahmed at the OFS under the Director of Freedom of Speech and Academic Freedom role. So he's very much taking an interest in these things. And some of these ambiguities, it's fair to say, are probably now being firmed up and becoming clearer with the other developments that we'll come on to in a moment, in particular the Higher Education Freedom of Speech Act. But certainly there has been some unsatisfactory ambiguity around what that pledge means and what you're covered, what you're agreeing to do and not do if you are signing up to that. There's been some updated ACAS guidance in April 2023. I'm not going to spend much time on this because it's fairly vanilla, confirms much of the stuff that we already know. It'll be on the slides, as I say, that you'll get after the session, but I've put that in there for sake of completeness. The big one of most interest is the Higher Education Freedom of Speech Act 2023, which received royal assent in May this year. It contains lots of provisions imposing obligations on governing bodies to secure freedom of speech at higher education institutions. And there are specific provisions within the Act around non-disclosure agreements. Regulations need to come into force to bring it into force, but that's expected to happen by the 2024-25 academic year. So at some point, we think in the next 12 months, timescales at the moment unknown. But when it's in force, this is the important bit, it will prohibit NDAs in relation to staff, students, members and visiting speakers around sexual abuse, sexual harassment, sexual misconduct, or other bullying or harassment that doesn't come within that sexual abuse, sexual harassment, sexual misconduct meaning. And any agreement that purports to any extent, the wording is, to preclude a person from publicising information about a relevant complaint or disclosing information about the complaint to one or more other persons is prohibited. And if signed, the agreement, which could be a settlement agreement, if it's got those provisions in it, will be an NDA, it will be void and invalid. It applies to HE providers and also the constituent institutions. So, for example, Cambridge and Oxford colleges. So again, you'll see relatively broad wording there. We've got the sexual abuse, sexual harassment, sexual misconduct, but also the other bullying or harassment. So very broad again, potentially covering a wide range of circumstances, not only those things that you might regard as serious allegations of bullying or harassment or matters linked to particular protected characteristics. So in terms of some of the implications that come out of that, what are those? Before we come on to some considerations around what you need to be doing. I think the first thing to think about is the types of misconduct covered by the Act, which I've already touched on. So we've got those two things, the sort of sexual abuse, harassment stuff, and the other bullying and harassment. Now, the wording is focused on information about the relevant complaint, which does suggest that it's probably okay to have clauses in the agreement, at least under the strict reading of the wording, which, for example, might seek to keep confidential the amount of a payment, because it's arguably not information about the relevant complaint that has been made. But we're still left at the moment with very broad wording that makes us think very carefully, okay, given we've got that bullying and harassment in general terms, we do need to think very carefully in all cases where there have been any allegations made about whether or not a settlement agreement is going to be appropriate, taking into account the wording of the Act and some of the other points that I'll come on to in a moment. Important point about complainants and perpetrators. So the Act covers individuals who are raising complaints. So the person who's raised the complaint, you can't enter into an NDA with them that's in breach of those provisions in the Act. It doesn't apply to perpetrators, so the person who's allegedly done the thing that's complained about. And obviously, in practice, that's very often the agreement that you'll be entering into. You'll be wanting to exit somebody against whom complaints have been made. So the wording of the Act doesn't cover an NDA with that sort of person, but you do, of course, have to consider more broadly, are you still happy entering into an agreement with somebody that potentially seeks to sweep some issues under the carpet that would be covered if that person was a complainant? You've got wider sort of culture, reputation, and values issues, I think, to be considering in that situation, notwithstanding that person's not strictly in scope of the legislation. That is obviously the culture and reputation point, the third circle on that slide. You've got to be very careful in what is an evolving area of law, where what is seen as acceptable only a few years ago is now seen as unacceptable. We could say where there could be adverse publicity if you're using a settlement agreement in a very sensitive situation. You've got to remember freedom of information requests, DSARs. There's some useful UK strategic guidance on staff and student sexual misconduct matters that gives some quite helpful, practical, strategic guidance on use of settlement agreements in some of these areas. But I think moving just beyond, okay, what does the legislation say, to what is our values-driven approach, what are we happy as an institution to be doing, is very important in this area. Linked to that, finally, you've got the draft OFS General Ongoing Condition of Regulation E6. Bit of a mouthful, but it is significant. There's been, this has some overlap with the provisions in the Freedom of Speech Act. And essentially what this draft regulation or condition of registration is trying to do is prohibit provisions that have the object or effect of preventing or restricting a person from disclosing information about allegations of harassment, sexual harassment, in any way which affects students. So it's got a student focus rather than a staff focus, but clearly there can be an overlap because often we're dealing with issues that involve students as well as staff. Consultation closed in May 2023. That could be introduced as a registration in time for the 23-24 academic year. Timescales on that are not yet entirely clear. What's interesting about that draft regulation is that in some ways it is narrower in scope than the Freedom of Speech Act, in that it only relates to allegations involving students, so not staff, but it's wider in that it's not limited to complainants, so potentially covering both complainants and perpetrators for those sorts of issues. And also it would prevent you relying on a clause already in existence that has been entered into in a previous agreement. As I say, that's still in draft form, not yet been implemented, but has some overlap with the Freedom of Speech Act. So where does that take us to? We've rattled through quite a lot of changes in this area. Clearly, the first thing is your general approach to clauses and your general principles, given the pledge that many of you signed up to, the Act that's going to come into force at some point soon, the draft OFS registration condition, and the new expectations and culture in this area. What is going to be your approach to confidentiality clauses in settlement agreements? You need to think carefully about that. As always, you need to think carefully on a case-by-case basis. What is going to be appropriate in the individual circumstances of this case? Where there is sexual abuse alleged, sexual harassment, sexual misconduct, or bullying and harassment, that's an immediate red flag. You've got to be very careful about confidentiality provisions in those sorts of cases. Is it appropriate to use any? If so, which ones are appropriate? Are we comfortable including a clause that covers keeping the amount of the payment confidential, but not the circumstances or background? Or is it a case where it's so serious, there's so many sensitivities, we don't even think we're comfortable doing that? There should be no confidentiality provisions. Has to be considered on a case-by-case basis, not always easy to give an across-the-board answer. I'd say challenge yourself. What really needs to be kept confidential? What is the real value of a confidentiality clause? What are you trying to protect? If it's breached and the employee goes public, what are you going to do about that? Are you really going to sue for breach of the agreement? Is it really going to be a deterrent? How will it look when the outside world finds out about it? All points to think about carefully. Do you want to think about now planning to level up in line with that OFS draft condition E6? So Clearly what we've got here is a range of issues that will affect both staff and student issues. We have policies and procedures that cover both staff and student issues, whistleblowing, bullying and harassment often. Do those procedures need to be looked at and updated across the board in light of these matters? And do you need to be implementing an approach to settlement agreements that effectively has quite a high bar for introducing confidentiality provisions? So are they clauses that are not included as a matter of course? They're opt-in clauses that you only include, having made sure that you've carefully thought about whether or not that is appropriate in the circumstances, and thinking carefully about that complainant-perpetrator divide, bearing in mind that the draft condition E6 potentially covers agreements with both, whereas the HE Freedom of Speech Act only, it seems, can cover NDAs with complainants themselves. Linked to that, what about training for HR teams? As Sam said earlier, settlement agreements are potentially quite complicated. They're statutory creatures. We've got all this additional guidance and regulation, adverse publicity, reputational issues out there. It's not a case of sort of painting by numbers, getting a settlement agreement that was used last time around and filling in the gaps. Do you need to have HR teams trained on this? Do you need to have guidance around when agreements are used? Do you need to make sure that an agreement is signed off by someone more senior in HR before it can be used? We have an automated settlement agreement product that contains guidance within it, which can be very useful in terms of churning out lots of settlement agreements, but making sure that you get these issues right. And finally, the approach of legal advisors. Legal advisors now are covered by an SRA warning notice in this area. So if you're dealing with your own lawyers on this issue, they will be saying, well, we are subject to certain conditions and restrictions on how we can advise on settlement agreements. And that will filter through to some of the issues that they will be advising you on and what they're prepared to include and not include in a settlement agreement. The regulatory context is now much more stringent than it used to be in this area. So I'm conscious of the time, and I wanted to make sure we had a few moments for questions at the end. Sam, I don't know whether we've got any questions that have come through that are worth picking up.
Yeah, of course. So we've got a couple, and I'll start with the possibly slightly simpler territorial question, which is, does the HE Freedom of Speech Act apply to Scottish universities? My understanding is that generally the provisions apply to English and Wales registered institutions, with some parts of that act applying to Scottish universities. But Alex, feel free to add some more detail if you'd like.
I'll be honest and say that's probably a point I'm not going to answer in this webinar, in that I'm not entirely clear on which bits will and will not. So I'll probably park that for now, rather than give some advice that could be a little bit misleading during this webinar. Any other questions that are there? What about the one that says, would the panel suggest where a complainant does not agree with the outcome of the investigation, not upheld or partially upheld, or the sanction and continues to repeat allegations publicly? Well, I mean, you always face a choice in any situation around, well, you know, what are you trying to achieve here? Clearly, what a settlement agreement can do is make sure that the employee leaves, the claims are settled, there's no liability for the institution in that respect, and you've got a separate issue within that agreement and what you reach with the employee in terms of the terms agreed around what they can and cannot say. You know, if you've got an issue where there's not particularly serious allegations in play, it's been, you know, an investigation that's upheld or not upheld some allegations, there's been no serious allegations of harassment and nothing sexual in the mix, you'll be more relaxed about including confidentiality provisions. But where there are allegations in play of bullying and harassment, or something more serious along the sexual lines, that's when you have to be very careful about what you include. And as I say, you need to be cautious about including any provisions where allegations have been raised by a complainant who's being exited that seek effectively to make them not, you know, gag them around what they can and cannot say about the circumstances about their complaint and what has happened to them during their employment. That's the key issue here, really.
And I think where you've got a complainant where you
someone's raised a question, the difference between a perpetrator and a complaint. Does it apply to a tactical complaint of bullying that someone raises later in a protected conversation about something unrelated, specifically prevent inclusion of a confidentiality or no slagging off clause? I mean, that's a good question. There clearly is scope for employees to raise, you know, complaints of what could be described as low-level bullying as part of a process that does then put the institution in a more difficult position because of the wording that we've got that's very broad in the Higher Education Freedom of Speech Act, reflecting the broad wording in the pledge that many institutions have signed up to. it remains the case that you will have risks attached to using confidentiality provisions in that scenario. It's probably fair to say where it's an allegation of low-level bullying raised late in the day, there's not been anything particularly serious raised, just around I'm not being treated fairly, the risks are going to be less significant than in the circumstance where someone's raised very serious allegations linked to a protected characteristic or of sexual harassment. But there's some ambiguity there, and you have to consider the individual circumstances carefully. What are you comfortable entering into? Does it really matter if the employee goes public? Are they really going to do so? Is somebody really interested? Weigh out those different risks and considerations. I know that's in some ways not satisfactory, but that is the balancing exercise that we're currently faced with. As I said earlier, the Act is not yet in force, so clearly there's still some flexibility. There's more flexibility than it would be if it's in force, but the reality is you've got the wider culture around these issues at the moment. You need to be thinking carefully around your values and approaches as an institution, and I think it's sensible to be approaching your thinking, your policies, your procedures in line with what's in the Freedom of Speech Act on this issue, and tailoring it around that with an eagle eye on that draft condition of regulation E6 as well. Right, well, I'm conscious it's just gone past, and we did promise it would be a half-hour session. So just leaves me to say thank you very much for joining us. I hope it's been useful. The slides will be sent out after the session. There'll be a recording available also on our website. If your friendly Mills and Reeve employment lawyers can help with anything, do let us know. We're always happy to unpick these issues in more detail with you and help you get things straight in this area. Otherwise, thank you very much. Have a great day, and hopefully see you all soon. Many thanks.